Civil procedure, service of process. The defendant must be provided with fair notice of the lawsuit. In the United States, process includes the delivery of an official summons by the court and a copy of the complaint filed by the plaintiff. Almost anyone can act as server of process. The exceptions are minors under 18 years of age and parties to the case, like the plaintiff herself. The most direct and obvious method of service is directly by hand to the defendant. This is known as personal service and can take place anywhere in the state. As we learned in the slideshow on jurisdiction, service within the state provides the state court with personal jurisdiction over the defendant. If the defendant is not at home, but another resident answers the door, service can be made to this person, so long as he or she is of suitable age and discretion. Service would not be considered performed if the documents were left in the hands of a young child, an incompetent, or a person that does not live at the property. Otherwise, service to the defendant can be substituted with service to a roommate or family member when the defendant is not home. Process is often waived today in order to save costs. The documents are mailed to the defendant with a waiver form. If the defendant signs and returns the waiver form within 30 days, process is considered waived. Defendants regularly waive formal process in order to avoid the associated costs. The federal rules allow personal service, substituted service, and waiver by mail. Some states allow additional methods. The federal court can deploy service methods allowed by the state in which it resides, or the state where service is performed. If process is not served within 120 days of the filing of the case is dismissed without prejudice. Dismissal can be avoided if the defendant cannot be located and there's good cause for the delay. It's not necessary that process be served on the defendant in a particular place. Process can be personally served on the defendant or an agent acting for the defendant anywhere within the forum state. If the state has a long-arm statute allowing service out of state, then service can be made on the defendant when he's in another state. Federal courts generally piggyback on the state's long-arm statutes for service out of state. The Bulge rule allows federal courts to serve process within 100 miles of the federal courthouse, regardless of whether this means crossing a state line. The Bulge rule only applies where out-of-staters are brought in as additional parties to an already pending action. Although the place of service for the defendant and his authorized agent are very broad, virtually anywhere in the United States, the place of substitute service is extremely narrow. Service must take place at the home of the defendant, and of course the recipient must cohabit and be sufficiently responsible for substitute service to be effective. As a corporation is not an individual, service must be made to an agent. Federal rules of civil procedure provide for service upon a corporation by delivering a copy of the summons and of the complaint to an officer, a managing or general agent, or to any other agent authorized by appointment or by law to receive service of process. The most common forms of service to corporations involve service to the CEO, the president, or another officer, or service to the corporation's agent registered specifically for service of process. Serving process on a junior employee in the company will be ineffective. Many U.S. companies are incorporated in the state of Delaware, but have their offices and operational centers in other states. These companies are required to retain an agent for service of process within Delaware. Process is commonly served on these agents when filing suit in Delaware courts. The courts don't want to discourage the participation of witnesses and parties to civil suits based on fear of being served with process. So if the only reason for the individual being in the state is to participate in another civil case, service of process on that individual is invalid. Witnesses and parties visiting a state with the sole purpose of participating in a civil lawsuit have immunity from service of process. There are special rules for service of process, the delivery of the summons and the complaint. But the service of subsequent documents exchanged between the parties can simply be conducted by mail. The special rules for service of process do not apply to service of answers, motions, amendments, discovery requests, and other papers.